the Supreme Court has issued an emergency decision that is already sending shockwaves across the country. Some say it could end gun permits nationwide. Others say that's an exaggeration. What makes this moment different is not just the ruling itself, but the fact that the Department of Justice is not opposing it. 26 states are backing one side of the legal fight. Permit-heavy states are scrambling on the other. And what happens next may reshape how Americans exercise their Second Amendment rights. This is not a headline breakdown. This is not political messaging. This video explains what the court actually did, what it did not do, and why this emergency decision matters more than it first appears. What was the Supreme Court's emergency decision? An emergency decision is not the same as a final ruling. It is a temporary order designed to pause, allow, or block the enforcement of a law while a case continues through the courts. This type of decision allows the court to act quickly, often before lower courts have finished reviewing the case. When the court steps in at this stage, it signals that the justices consider the legal question both significant and urgent, requiring immediate attention to prevent potential consequences while the legal process plays out. Despite the attention these orders receive, it is important to understand their limitations. Emergency decisions do not rewrite the Constitution, overturn laws permanently, or make a final determination on the legal issues involved. They are temporary measures meant to maintain the status quo or address urgent concerns until a full review can occur. Recognizing this distinction helps the public and lawmakers interpret these rulings accurately, avoiding misconceptions about their scope or impact. In short, an emergency order is a pause, not a conclusion, a tool to manage urgent legal questions without bypassing the full judicial process. Why people are saying gun permits are ending. Much of the confusion comes from how permit systems differ across states. Some states still require permits before carrying firearms such as handguns and other regulated guns. Other states have moved to permit-less systems for certain firearms in recent years. This emergency decision questions how permit requirements are legally justified, not whether states can regulate guns or firearms at all. It does not end permits. When people say permits are ending, they are often reacting to possible future outcomes, not current law. Right now, permits and firearm regulations still exist where they are already in place. The role of the Department of Justice. One of the most unusual aspects of this case is that the Department of Justice is not opposing the emergency order. Instead, it has supported the legal position behind it. This does not mean the federal government is seeking zero gun or firearm regulation. Rather, it reflects the DOJ's view that the specific legal framework being challenged may conflict with constitutional standards established in earlier court rulings. That support adds weight to the legal argument, but it does not decide the outcome. The case is still ongoing, and any final resolution will come only after the full judicial process is completed. Why 26 states are involved? When states choose to join a case, it usually signals that the issue has national impact. In this situation, 26 states argue that certain permit requirements for firearms, guns, and handguns do not align with constitutional protections as interpreted by earlier court rulings. They believe some permit systems place limits on the carrying of firearms that may conflict with established legal standards. Other states strongly disagree. They argue that permits related to guns, firearms, and handgun carry are an important part of existing public safety frameworks. These states warn that weakening or removing permit requirements could affect how firearms are regulated and monitored at the state level. This split highlights a deeper constitutional question that goes beyond any single type of gun or firearm. Who has the authority to set limits? The states that regulate firearms, or the courts that decide whether those regulations meet constitutional standards? Permit-heavy states and legal uncertainty. States with strict permitting systems are now entering a period of legal uncertainty. Some states have begun reviewing their existing laws that regulate firearms, guns, and handgun permit requirements to see how they align with recent court actions. Others are choosing to wait for guidance from lower courts, knowing that future rulings will help clarify how firearm and gun regulations should be applied. At the same time, some states are quietly preparing alternative regulatory approaches that would continue to govern firearms, guns, and carry permits if current systems are limited or revised. Nothing changes overnight. Existing firearm and gun laws remain in effect, and permit systems are still operating where they already exist. However, the legal ground beneath these systems is shifting, and that growing uncertainty, rather than immediate change, is exactly why this emergency decision matters. How this connects to the Bruen decision. Many legal experts describe this as the most significant gun rights case since New York State Rifle and Pistol Association versus Bruen. That decision reshaped how courts evaluate gun and firearm laws by shifting the focus away from modern policy arguments and toward historical tradition and constitutional history. Under the Bruen framework, courts now ask whether a firearm regulation is consistent with the nation's historical understanding of the right, rather than whether lawmakers believe it serves a current policy goal. This emergency order tests how far that standard reaches and how it should be applied in real-world permitting systems. Importantly, this is not about one state, one law, or one type of firearm. It is about legal methodology. how courts analyze gun laws, what evidence they rely on, and how future cases will be judged. The outcome could influence how firearm regulations are reviewed nationwide, well beyond the specifics of this single dispute. What the court has not decided. The Supreme Court has not ruled that all permits are unconstitutional. It has not ruled that states are prohibited from regulating firearms or guns, and it has not declared gun laws invalid across the entire country. All of those questions remain open. They have not been fully argued, reviewed, or decided by the court in a final ruling. That distinction is important, because much of the public confusion comes from treating an early procedural decision as if it were a permanent judgment. The emergency order does not eliminate existing permit systems. It does not erase firearm regulations. And it does not override state authority overnight. Instead, it temporarily addresses how a specific legal issue should be handled while the case continues through the lower courts and moves toward a full review. Emergency orders are limited by design. They are meant to manage timing, enforcement, and legal risk while judges examine the deeper constitutional questions. They do not rewrite the Constitution, and they do not settle long-standing debates in a single step. What this order actually does is set the stage for what may come next. It signals that the court views the legal issue as serious, unresolved, and worthy of careful consideration. The justices are indicating that the question raised could have broad implications, but that those implications must be examined through the normal judicial process. For now, permits remain in place where they already exist. States continue to regulate firearms and guns under current law. Courts will continue reviewing cases, weighing arguments, and applying constitutional standards. In short, this moment is about process, not conclusions. The legal path is still unfolding, and any lasting change will come only after full hearings, detailed opinions, and final rulings, not through an emergency order alone. What happens next? Lower courts will continue reviewing the case, examining the legal arguments and applying existing constitutional standards. This phase is critical because it is where evidence is evaluated and detailed reasoning is developed. In the meantime, some states may choose to temporarily review or adjust their laws related to firearms and permit systems as they wait for clearer judicial guidance. These steps are often cautious and limited, aimed at reducing uncertainty rather than making permanent changes. The Supreme Court may eventually decide to take the case for full review, or it may allow the lower court process to continue without further involvement. Until that decision is made, the legal system remains in motion. Nothing is settled yet. This is not an endpoint. It is an ongoing process, and any lasting outcome will come through continued court review, interpretation, and time. Gun law debates did not begin with this decision, and they will not end here. But this moment stands out, because it shows how courts, not legislatures, are shaping the future of firearm regulation. Understanding what actually happened matters more than reacting to headlines. If you want clear explanations, legal context, and calm analysis without noise, consider subscribing to the channel, because the fallout from this decision is only just beginning.